Please be seated. We'll hear argument in 23-704, Seward versus Santander.
Court, Mr. Smith and Mr. Walsh will present argument for the petitioners. Petitioners have reserved 3 minutes for rebuttal. Mr. Walsh will open with the first 7 minutes and will present the rebuttal.
May it please the court, David Walsh, I represent Officer Seward and point-to-point security. I'll be talking about the election of remedies issues under the Tort Claims Act and the immunity issues, and I'll just comment that it's not at all intimidating with all the people behind me. I'll start with, I'd rather answer your questions in my limited time, so fire away. But also I have 2 reasons I think that Officer Seward went on duty during this event at the Home Depot. First, under the Code of Criminal Procedure, Section 2.13, as a 24/7 duty of an officer, a peace officer, they have to intervene to prevent and suppress crime. Likewise, under the DPD off-duty policy 42103, requires off-duty officers to respond to crimes in progress. Officer Seward received a credible report from Painter that Juarez was committing shoplifting, and that created this on-duty obligation for him to respond to that crime. Second, even if you take the respondent's theory that, oh, this is just a criminal trespass warning issue, the DPD policy on criminal trespass warnings that Officer Seward, as part of his off-duty work, was required to follow, has a series of steps that he must follow, including investigating to get ID, to confirm who the person is, and second, to check for warrants, among other paperwork that must be completed. And so he's got to detain Juarez to investigate that issue, to figure out who he is so he can make sure the paperwork is correct. And that furthers DPD and policing policy because we make sure we have proper paperwork to know that the right person has been identified, who he is, so if he comes back, we can actually have a crime of criminal trespass prosecuted and a conviction for that. And second, it furthers DPD policy because he is acting uniformly with all other uniformed officers that are on duty. They're all doing the same work so that when they stop people, they are checking for warrants if it's required under the circumstances.
So you agree that a private landowner can warn somebody of criminal trespass, but what you're saying is because the person giving the warning in this case is a Dallas police officer, the officer had to go through additional steps that a private landowner might not have to?
Correct. And that's back to, had the DPD policy not existed on how to issue a criminal trespass warning, he might just issue a criminal trespass warning like any other private citizen might issue a criminal trespass warning. But because he's required to follow the DPD policy, which has all these steps in it, including getting the ID, checking for warrants, and then completing the paperwork to make sure we have the right documentation, show if the person shows back up, we can have a prosecution. That's all different than what a private landowner might actually do and accomplish if the private landowner is doing that.
And so are you arguing that that's a negligence claim as opposed to the premises liability claim?
That's Mr. Smith's argument on this. I'm only arguing whether Officer Seward was on duty or not on duty.
Okay.
Did the Home Depot policy also require him to take those steps?
No, the Home Depot policy, first of all, Mr. Painter was confused apparently on the law because he thought he had to involve an officer to issue a criminal trespass warning. But the policy at Home Depot didn't require any of the steps like checking for warrants or obtaining ID. And in fact, a shopkeeper might not do the step of getting the ID to verify who the person actually is with the date of birth and the proper name and things like that. It only becomes protracted here because Mr. Juarez doesn't have ID and they find a sound-alike warrant when Officer Seward calls into dispatch, and the sound-alike warrant is close enough that we think we need to investigate further. And then by the time that the on-duty officers arrive, they pulled up the warrant with the guy's picture, and so as soon as our guy gets to the police car, that's the guy. And I would assume, likewise, they could have made that assumption themselves when they walked in and saw the picture and then saw the guy sitting in the Home Depot Asset Protection Office. But
If there had never been a shoplifter that day and Officer Seward had served his however many hours his shift was that day for Home Depot, would there have been any moment during that day in which he had been on duty?
We are not arguing that. I think you could make an argument that You've expanded the police force, and under the Code of Criminal Procedure about preventing and suppressing crime, standing there by the checkout area, you might prevent and deter crime by doing that. But I don't think, we're not making that argument. And
But what you are arguing is that once he was asked to issue the criminal trespass warning, DPD policies then governed what he had to do, even as a Home Depot employee, and therefore he became on duty.
correct.
Now, are there DPD policies that govern what he must do in a normal day working for Home Depot? That because he's a police officer, you have to do this or not do this while you work as a private security guard?
So there is a policy from DPD that says a DPD off-duty officer in uniform must follow all the policies and procedures that exist for on-duty officers. In your ordinary course of things at Home Depot, where nothing is happening that day, he's not doing anything pursuant to DPD policy. But he gets a report of crime in progress. There's a DPD policy on responding to crimes in progress when you're off-duty, in addition to the Code of Criminal Procedure, and he's asked to do the criminal trespass warning, for which there's explicit policy of what to deal with on that. The one other thing I'd like to talk about very briefly is just kind of this causation issue, and I know that causation is not normally looked at from an immunity perspective, but this was an entirely, essentially peaceful encounter with Juarez, knowing that we're checking on warrants, voluntarily agreeing to go back to the Asset Protection Office with us, and he's entirely peaceful until he learns that they're about to arrest him. And that is triggered by us calling to get the cover unit, the on-duty officers to show up and check the warrants. But so that's all that is on-duty conduct, and nothing that had occurred, even as the Court of Appeals views, I think incorrectly, but even in the Court of Appeals version of that, all that off-duty stuff never caused any harm to anybody. It's only when we call back in after confirming the warrant, which is only after we went on duty according to the Court of Appeals, when we called in to get the cover unit to come.
Well, I don't understand that argument, because there's a dispute about whether Officer Seward performed a protective Terry frisk at the time that they first approached Mr. Juarez, right? And Mr. Painter says he didn't see that. Officer Seward says, I did do that. If he did it, he didn't do a very good job of it, because it turned out Mr. Juarez had a gun, right?
Correct.
So couldn't that be a cause, since of him shooting these people later when they said we're about to arrest you?
Well, but if we didn't do a Terry frisk, right, that would be consistent with Home Depot policy. If we did do a Terry frisk, that would be an on-duty act, right? So you can't hold a shopkeeper and an off-duty officer to on-duty standards, right? If we
Well, there's a dispute about whether he did it at all.
If he didn't do it, right, okay, that's his judgment of whatever. Does he have to? If you're saying he has to do a frisk, then every shopkeeper must frisk somebody they detain. That can't be the law. There's no law that says that. And that's what their position boils down to, is if either we're going to let all criminals steal from us and take our stuff, or we're going to detain them, frisk them, and handcuff them. There's no middle ground in their version of this event. And so either we didn't frisk, if you believe Painter, and we just didn't frisk him. Okay, shopkeepers don't have to frisk people. We're not on duty at that point. We then use the radio and become on duty according to the Court of Appeals. Or we did frisk him. The only authority to do that is for safety, which is an on-duty act.
Well, I think their position is that basically what you're saying is that anything that's going to lead to a lawsuit is going to be an on-duty act. So you should hire a policeman to do it instead of a private security person, because then you're never going to be liable.
Except for we wouldn't. There are certain facts that go on for which, if you believe that we did a Terry frisk, we see the can of mace and we're worried about safety of everybody around us at that point, at least if you're believing Officer Seward's testimony. And that's why it's more of an on-duty act, complying with the non-consensual protective safety frisk under the DPD policy.
Is it your position, though, that it doesn't matter whether a Terry frisk occurred or not, because he'd already gone on duty the moment he was asked to come over to assist with the criminal trespass warning?
Or even responding to the crime in progress. Under either version, he's on duty from getting the call to go over to where they are.
And that's the moment immunity attaches?
Correct.
Does on duty, in your mind, is that phrase completely synonymous within the general scope of his employment?
Correct. And there's
To you, it's completely synonymous. There's no There's no way you can be one and not the other.
Correct, because at least the case law from this court, if there's any act that's in furtherance of the government's job responsibilities, that's an on-duty act, even if it's done for bad motive or other reasons. So even if he's doing something for a security purpose, if he's following on-duty policies and procedures, that's in furtherance of DPD having all of its uniformed officers look the same. It's in furtherance of complying with the DPD policy, et cetera, even if there are other motives or obligations going on.
And so you can sue DPD for that,
Yeah.
except that they're immune.
In this instance, yes, and they've not made.
Well, in pretty much every instance where this comes up, they're going to be immune, right?
In this specific fact setting, yes. I mean, and the workers' comp.
In the private security setting where something triggers them to go on duty.
But there might be exceptions to the immunity that could exist under the Tort Claims Act. It's just they've not pled any, they've not substituted in DPD, they've never done any of the things under the Act. It's just under the election of remedies, Officer Seward is entitled to be out because under the election of remedies, you're supposed to substitute in his employer.
Does the manager of the Home Depot have no right at all to control the hired officer once the sort of on-duty switch is flipped?
Correct, because he can't control what a peace officer does in carrying out his peace officer obligations. I don't know that this court has said anything about that, but all of the intermediate courts are uniform on this issue, that once they go on duty, the responsibility of training and hiring and supervising falls to the policing department, not to the store that hired them to do that.
So can they stop paying him at that point?
They can.
The point is, if he says you're fired in the middle of that, he has to continue doing what he was doing.
Because it's a policing activity.
Any other questions? Thank you, Mr. Smith. Mr. Walsh, we'll hear from you.
Just a second, Mr. Smith, that was
I'm
Mr.
sorry.
Walsh arguing for point-to-point and Seward. And may it please the court, I note that I'm already almost done with the time available to me to present argument. I appreciate some minor indulgence in continuing with my argument if possible.
The time on your clock is your time.
Oh, okay, thank you. The logical starting point in my presentation is with reference to the undisputed fact that Seward made a warrant check call by the time Juarez had already been taken to the back office. And therefore, Seward had already gone on duty as of that time. And that call occurred before Seward called for a cover unit to come and assist him in investigating the police activity of whether Juarez was subject to a warrant. So Santander and Almeida went to and entered Home Depot's premises for reasons entirely unrelated to Home Depot's business. This meant that they were on the premises as licensees, and Home Depot submits that in a situation like this, in terms of duties of those present, it was the officers who had the duty not only to protect themselves, but also the property owner and its guests from any risks of harm presented by the criminal suspect. Here, the suspect had a gun in his pocket. The on-duty officers did not search him for possession of weapons. They did not handcuff him. They did not restrain him. They did not put him in their squad car and conduct their investigation there, or take him out to a public street and conduct the investigation there. It simply can't be Texas law that in this situation, it was the property owner who had the duty to critique their conduct, and then, when the conduct was found subjectively lacking, to interfere with their work by telling them what to do, which was safe, or doing their police jobs for them by searching or handcuffing the suspect.
So is this your superseding clause argument?
No, it's a no-duty argument in the first place because, well, if we were to take it strictly according to the legal principles that are applicable, the first thing you would do is point to what claims have been asserted. Negligent activity claims. This court has always held that a negligent activity claim is one that involves a contemporaneous act to the occurrence of the criminal act, which contributed to the occurrence of that act inflicting the harm.
Such as failing to do a proper Terry frisk.
No, see, failing to do a proper Terry frisk would be a failure to provide security. It would be something in the nature of...
Well, if you're doing the Terry frisk and you don't do it well, that seems like an activity that seems like misfeasance rather than nonfeasance.
And if you were to argue that, you would say, well, that occurred well before Juarez brandished a weapon, had nothing to do with that. When the police...
Superseding cause argument.
Well, I don't, it is potentially the superseding cause argument in that
And then the question would be, is the activity of not finding the gun too remote from later when he finds out he's going to be arrested, pulling out the gun and shooting two people?
Well, in regard to the superseding cause argument, you have this. Painter wanted a criminal trespass warning issued. All he wanted Seward to do was take him to the back office, issue the warning, let him leave. Juarez would never have been arrested. Santander and Almeida would never have entered the premises because they would have had no reason to enter the premises. They entered because of the risk that and the understanding they were likely going to have to arrest Juarez.
But you knew they would have to do that by hiring a policeman, right? Because they have to, as we just heard from the other counsel, they have to follow DPD policy. So surely Home Depot knew that when they chose to hire police officers who were off duty, who had to go through those steps in order to issue the criminal trespass warning, because you could have hired a private security firm that wouldn't have had to go through those steps.
Well, there was no evidence in the record that Painter understood what was involved as a police function that Seward had to perform.
Well, Painter probably didn't hire Seward, right?
Right.
Okay.
Right. So he was accustomed to simply issuing criminal trespass warnings himself. Now, suppose Juarez came back and he called the police. Well, all he would have was, I created this piece of paper at some time and this man's a trespasser. The police may or may not believe that. They may not even come. But if the criminal trespass warning is in the system, now it's understood by the police that he's a trespasser already and he can have him ejected immediately. So Painter sees, oh, I've got an off-duty police officer here. I'm going to take advantage of the opportunity to have that officer issue the warning himself, which then won't leave any questions about Juarez being a trespasser were he to come back. But my point as to superseding cause was all Painter was doing was initiating a sequence of events that would have led to the issuance of a warning. Here you are, you're free to go, don't come back.
So in the ordinary general case where the plaintiff seeks to impose liability against a landowner for the third-party criminal acts of another, the landowner doesn't have an encounter with the perpetrator. In other words, the crime happens on the premises, and the idea is that you should have known that this crime or something similar would happen, and that's a premises liability case. Why shouldn't this fall into the negligent activity case or negligent activity bucket? Because in this instance, we have the landowner having an encounter with the perpetrator of the crime.
Because there was no negligent activity on Home Depot's part that was contemporaneous with the commission of the crime. Once Santander and Almeida arrived, they were in control of the situation and they dictated everything that occurred from that point forward with respect to Juarez, which had absolutely nothing whatsoever to do with Home Depot's business. They were simply using the premises for their purposes. So that made them licensees. And as ordinary licensees, the only duty that was owed to them by Home Depot was to warn them of a dangerous condition on the premises. That condition had to be the one that directly inflicted the harm, which here was...
This is your firefighter duty argument, right?
It gets to that.
Rule argument. Because the firefighter rule is not a rule of immunity, it just changes your status to that of a licensee, right?
Well, they were licensees already because they came to the premises not at the invitation of Home Depot, express or implied, but for their own purposes to investigate some warrant that had nothing whatsoever to do with Home Depot.
So the
in that
firefighter
sense,
rule is kind of irrelevant in this
well,
case.
no, what I would do in my chain of argument is argue the following. As ordinary licensees, they were only owed the duty to warn them of a condition that Home Depot knew and they didn't, which inflicted the harm, which was the weapon, which nobody knew Juarez had. Then you say, well, they weren't ordinary licensees. They were actually police officers. And so as police officers, the firefighter's rule comes into play. And in that instance, there is no duty to warn them of risks that are inherent in the performance of their duties. So here you have someone they knew to be unrestrained. They had seen his photograph on their computer, knew that he had an outstanding arrest warrant, knew they were entering for the purpose of arresting him. They encounter Seward and have no communication. They walk into the room, see him there unrestrained, waiting to hear Seward tell them that the warrant's been confirmed and they need to arrest him. So they know that they are going to approach someone who is unrestrained, has an outstanding warrant, and is about to be arrested.
It seems like you get to the same place with your ordinary licensee argument.
I think you can.
Okay,
I
and
absolutely
most
think you
states,
can.
it seems like that have adopted the firefighter rule have done so by just giving them licensee status without necessarily this special overlay of what's inherent in the job. So why do you think we should adopt that rather than just, I mean, Texas we haven't adopted the firefighter rule, but why would you say we should adopt the version of it that you're proposing rather than simply treating them as licensees?
Well, I think the only distinction would be, in the case of an ordinary licensee, it's the only duty is to warn of the dangerous condition that caused injury if you knew about it and they didn't. Under the firefighter's doctrine, you don't have a duty to warn them about anything, whether you knew of it and they didn't, if it was inherent in the performance of their functions, because they're there to protect you.
Is that the way all states have applied it? I'm not sure it is.
I believe so, Your Honor, except for the 4 states that have decided not to recognize the firefighter's doctrine any longer. I could be incorrect, but
the restatement's recommending abolishing it, but I understand that several states have adopted it.
And what's interesting is that in the case where this court did acknowledge the firefighter's doctrine, you had Justice Gonzalez and Justice Abbott in a concurring opinion saying that they believed that it should be endorsed and recognized by this court in any case, whether it's a premises case involving a dangerous condition or whether it simply involved a negligent activity. And they didn't believe that it even needed to be applied in the case of an emergency, because in that case, Jewell versus Arrington, the officers were responding to a complaint that there were people protesting at an abortion clinic, preventing the entry. An officer went over, tried to remove someone, received a back injury, and those justices in that case said, that's not an emergency situation, that's not a premises case, but we advocate for the adoption of that doctrine in any case because police are supposed to protect the public, and the public policy behind the doctrine is not to discourage people from contacting police and seeking their assistance, which might occur if they have to independently evaluate, is this an emergency? Are they going to be confronting risks that are inherent in the course and scope of their duties? And if I'm potentially liable to them for what occurs, if the answers to those questions go against me, then I'm not going to call the police. So,
Any other questions? Thank you, counsel.
thank you, Your Honor.
We'll hear from the respondents.
May it please the court, Mr. Illick will present argument for the respondents.
Good morning, and may it please the court. My name is Niles Illick, and it's indeed a special honor to be here on this historic day. Thank you for having us. I've heard petitioner's argument, and I will respond. I would like to address 3 things, and I intend to address them in this order. The first one being the question of Seward's immunity, the second one being negligence versus premises liability, and third, the firefighter's rule. I think before we begin discussing the question of Officer Seward's immunity, we need to remember that he's here under 101.106F. And 101.106F places the burden on the petitioner, in this case Officer Seward, to establish that any of the disputed negligent acts are within the scope of his employment, and we could have sued DPD. If a fact issue exists on any of these, then dismissal is inappropriate. I don't think anyone has disputed the law that applies. We know that it's Lavery, and we know that it's Garcia. I think everyone agrees that that is the governing law here, and if we can just sort of generalize what that law is, the question is whether a connection exists between the employee's job duties and the tortious conduct. Now, I think we begin the meat of our argument with where the Court of Appeals left off. And the Court of Appeals left off finding a fact question. And they found a fact question determining that a reasonable fact finder could conclude that before Seward did the warrant check, Seward was merely assisting a private employer in enforcing the employer's policies in ejecting a potential trespasser. Now, this, of course, ends as soon as we do the search for the warrants, because Home Depot has no interest in searching for warrants that have been issued from other cases. So that brings us to the question of what are the objective facts this court should be looking at. And I'm going to ask this court to look at least to 4 objective facts and to find that Officer Seward was off duty when this happened. And I think where we begin with that is with the acknowledgement that the other side petitioners have made, and that is that Officer Seward started off duty. Now, they flirt with the idea that 2.13 puts any police officer in uniform always on duty because that has a deterrent effect. But they ultimately concede that point, and I think they conceded correctly that point this morning, that Officer Seward starts off duty. That's our first objective fact. The second objective fact is that Officer Seward does not see Juarez commit a crime. Painter and Seward are in different parts of the Home Depot. Painter reaches out to Seward and says, hey, I think this guy might be shoplifting. There's some different versions of exactly what he says, but it's Painter reaching out to Seward. Seward doesn't see the alleged criminal act at all. So we have objective fact 1, he starts off duty. Objective fact 2, he does not see a criminal act.
Can you tell me what that second objective fact matters? Why does that matter?
Sure. I think that if he did see a criminal act, I think that would go into Articles 2.13, 14.01, 14.03. If he is witnessing a criminal act, that's going to be a different situation that will much more easily trigger 2.13 or 14.03.
More easily trigger it, I get that, if you see it with your own eyes, but are they on different sides of a line, or is it simply being told by someone else, I think this is happening, makes you just closer to the line?
It gets you closer there, but I don't think it gets you over the line. It certainly didn't here, and I'll tell you why with the third objective fact, if I may. When we look to the third objective fact, what we see is Painter directing everything. Now, as counsel, I was pleased to hear him acknowledge this morning, there's no statute that says if there's an ongoing crime, there's a police officer responding to that crime, that somehow a Home Depot loss prevention officer should be the one telling that police officer how to act, right? So if in fact Officer Seward is on duty, he should be making his own decisions under DPD guidelines, our laws, all of that about what he should be doing. But what we'll see in just a minute here is that, in fact, it's Painter who is directing it. Now, we get to that with Painter first calling Seward. Seward responds. Painter then says, I think Juarez is hiding behind the insulation. Seward goes over there and looks. Painter says, get him out. Seward gets Juarez out.
So I hear you to be arguing that given all these facts, which I don't know that any of them are under dispute, but correct me if I'm wrong about that, the court should decide as a matter of law whether or not the officer was on duty, as opposed to the way the Court of Appeals saw it, which is that's a fact issue.
I think we can leave it as a fact issue. I don't think it has to be decided as a matter of law in this case, and I'm not sure the court should even do that.
Well, if the facts are known or sort of undisputed, we all agree what the circumstances were and what was going on, is it a legal question for the court as to whether those facts make the officer on duty, or is it somehow a fact question for the jury?
I think that it's premature at this point. The court can say there is a fact question. I think that's what the court should find. I think if the court said as a matter of law he was on duty, I would love that. But that, and I'm going to argue against myself here for a moment, but that would, I think, be premature.
But my question is, what are the facts that are in dispute? Because if the facts themselves are not in dispute, then it seems to me it's a legal question for the court as to whether he's on duty. And that legal question may be a close call, but it being a close call doesn't make it a fact question.
Sure, and I feel like I'm arguing against myself here, but I think as the case develops, there may be other discovery, other things that go on that resolve some of the issues and develop this further than we have in, say, this immunity context. Maybe that gets developed further and there's a different determination later on. But I think where we are is that we have a fact question. If the court decides to resolve it as a matter of law, that's fine. But I think what we need to look at and what we need to see here and what counsel for petitioners has told us is that once a police officer goes on duty and he's acting in response to a criminal act that's going on in front of him, the Home Depot official has no authority, no permission, no statutory right to tell that police officer how to act.
If somebody comes into my house and I call the police and I say, get him out of my house, and they get him out of the house, have I taken control of the police?
You have not taken control of the police. The police presumably are still making their own decisions about what should happen there.
But why would that not presumably be the case for a Dallas police officer?
Sure, I think it's a different case here because we see a pattern over a period of time where Painter's telling Seward, get him out, come over here, I think he's doing this. We're only gonna issue a criminal trespass. When Juarez falls on the floor and does a flop that European soccer players will be proud of, I think Painter says, get up, we're only gonna do a criminal trespass. Seward is going along with all of this. Seward is following the direction of Painter, and that's objective. We're not looking at what he thinks, we're not getting into the subjective evidence, we're looking at it objectively.
Well, what would you suggest if he had not become a robot of Painter that he would have done differently?
If he had been a police officer, if he had been acting on, let me ask this, are you asking me if he had turned on duty, how would he have acted differently?
Yeah, I get, well, if you're suggesting, well, he's just following commands, one understanding would be, well, all of the commands are exactly what he was going to do, and he's not gonna stop and say, well, just so you know, the reason I'm gonna do this thing is because I want to do it, not because you told me to, which maybe wouldn't be a sensible thing to do in those
Sure, I think.
But if there's something different that a normal police officer would have done, and that here, Painter's telling him to do something that no police officer would do, that might be something.
Yes,
What is that?
well, forgive me, I didn't.
No,
mean to
please,
interrupt.
what is that thing?
I think that you see a deviation from DPD policies that would have been followed had Seward been acting directly on duty patrol policy. He would have done the things, and my brain is blanking exactly on what they are, but the policy is there. He would have followed that DPD policy instead of following what Home Depot wants him to do. You have a fork here. You can go the on-duty route where he is obliged to follow every single police procedure that would be involved. Or you have the fork that says you're following the Home Depot procedures where Painter is leading it. Painter is making the decisions, and Seward is just really there in case this guy runs off or starts to create a fight or does something else. That's what the record shows.
Is it Home Depot policy to request a check for outstanding warrants in connection with a criminal trespass
No,
citation?
Justice Bland.
So at that point, you concede that he became on duty?
Yes, Justice Bland.
So, at what point did that switch happen? At the point he called for backup and asked for the warrant check? Why wouldn't it have happened before when he said, okay, I'm going to cite for criminal trespass? Home Depot policy wouldn't require this, but I need to identify the person that I'm going to cite. I need to check to see if there are outstanding warrants for that person, and I need to write a report.
Okay, Justice Bland, I think that's an excellent question. And I think what we see here is going back to this still following Painter's direction. He's doing what Painter tells him to do. If he's on duty, he being Officer Seward, if Officer Seward is on duty responding to an active criminal activity that he has observed or he is involved in, stopping, then he shouldn't be following Painter. What he's doing, and we see objectively, is him following Painter. And as he follows Painter, we see that we don't go down the road of the Dallas police policies. We instead go down the road of Home Depot. Now, eventually, he does in fact reach out. He does in fact make the call. We don't know if that's when Juarez is on the ground or when Juarez is back in the office. But I think what we have here is a clear indication that at this point, we have objective evidence that shows Officer Seward is acting as an agent. He is acting on behalf of Home Depot. He is not acting as he would as a Dallas police officer.
Up until the warrant.
Until the search, until the request for the warrant.
And then you're conceding at that point things
Yes,
change.
yes, I don't think Home Depot has any interest at all in searching for a warrant that necessarily would have issued out of another case, right? So
Point is that he acted negligently before that time.
he
by
did, yes,
Failing
he
to do
did.
the Terry frisk properly, or what?
Well, there's several things. I think we can say Home Depot acted negligently, Painter acted negligently, Seward acted negligently, but they acted
In what
negligently.
way?
Sure, let's just start with Seward because I think that's where your question is, Justice Busby. Seward either didn't do a Terry frisk correctly or he didn't do one at all, right? We have, as you pointed out earlier, disputed evidence, but as the Court of Appeals pointed out, there's a Terry frisk which is done for the purpose of finding a gun, right? It may not find like some illegal pill in your pocket or something, but it's going to find a gun. That's what a Terry frisk does.
Well, and your friend on the other side says, well, that shows that he was acting as a police officer because you couldn't have done a frisk like that if you were just working for Home Depot.
Well, I don't see where counsel gets that argument. Home Depot has made a policy not to search because they're afraid of their image, right? They're afraid of that damaging their image. But I think that there are many instances where, say, you're executing a shopkeeper's privilege, you would be well within your rights to be concerned that the person you're executing that privilege on has a gun, and you need to find out whether or not that person has a gun before you before you detain them. That is just a matter of safety. And so the fact that Home Depot didn't have this policy, that decided not to do this, doesn't mean that it can't be done. In fact, if I was at a football game not too long ago and whatever was in my shoe kept setting off the alarm, it wasn't a police officer there, but I had to go through the pat down and the search. It was not a police activity. It was just, I don't know, something in my shoe that was setting it off. And I think the same would be true with this. Now, Home Depot made that policy, and that was their decision, and I think it was a poor decision. It's part of the reason we have one dead police officer and another one who caught a bullet. But I don't think it means it's exclusively a police function.
Would there be an obligation?
Does the evidence establish that Seward, that Painter asked Seward to come issue the criminal trespass warning?
I think Painter says, I just want to issue a criminal trespass warrant. I want to issue one. I don't think he says overtly, go and do it. I think what he says is all this is going to be is a criminal trespass warrant. And he says that over and over and over again. And he's making the decision about the outcome of this, whether it's...
Effectively, then, the decision is Painter's decision that Seward should issue a criminal trespass warrant.
That a criminal trespass warrant, not a criminal trespass warrant, criminal trespass warning is going to be issued. That's Painter's decision.
But by Seward.
I think you can find a fact question on that. I think there are times where Painter is saying there will be only a criminal trespass warning, not saying who does it, and then there are other times that it says the other. I think we need it to be developed further.
Assume with me that the evidence conclusively established that Painter asked Seward to issue a criminal trespass warning. What I heard your friend on the other side say is that DPD policies would then kick in and govern how Seward did that differently than if a non-DPD officer was doing it. Do you agree with that?
I agree that the DPD policy would direct Seward in how he was supposed to issue a criminal trespass warning, and that would include things like doing a warrant check. But what I dispute with you, and I think we've been over this, is that there's a fact issue about whether or not that is what actually occurred.
Justice Hedl.
So I'm thinking about whether there is an obligation in your view for a private landowner. Let's separate Seward for now.
Okay.
And just think about the private landowner and the scenario where you have a private party and Justice Young gets concerned about someone who is uninvited and comes and makes a phone call to the police department, does he have an obligation? What duty does he have to investigate whether the person might be dangerous, might be carrying a weapon? It seems to me that one of the implications would be that if Home Depot did any of this wrong or failed to do something like that, that would also apply to just a private landowner and a private residence. And I would certainly be concerned then about the deterrent effect, people not wanting to call the police if they were wary of doing all of that. So how does this apply outside of the shopkeeper context?
Sure, and Justice Huddle, I hope, that was a long question, I hope I answer everything. If I don't, please let me know. First of all, I think the important thing to start with is that these are intensely fact-specific. So in a situation where, let's say I have 8 or 9 people at my house and somebody shows up who's not invited, I look at those facts and I decide, is this a situation in which I need to act? Or is it a situation where, oh, I kind of know who that is, they're associated with someone I know, that person has been a Jesuit priest for 19 years and he's always been a good character, I feel okay about that. Or do we have a situation where, man, that guy is really, the person they came with is really got a long rap sheet, their cases maybe have been heard across the hall, and I got some concerns there. So I think these are intensely fact-specific questions. And when we look at the facts here, we've got some really strange facts, right? We've got somebody who we think may be committing a criminal act, who's hiding behind insulation, who is flopping on the floor. These are strange and unusual behaviors that should ratchet up or increase your concern about what this person's going to do.
If a person is acting that suspiciously at my home, do I have an obligation to warn the police? Do I have an obligation to search the person?
You have an obligation, it depends. If you're there by yourself, that's different, but if you have others there, you have some obligation, I think, to make sure, to act. You have some, I don't know that you have an obligation to do a specific thing, but if let's say in this case, they detain him, they pull him back, they put him in the back part, the police should know about what's going on. If the police come to your house and you call the police about this person who's there, and this person, let's just say, has been, I don't know, shooting mace off in the kitchen, you, I think, would do the police a great service to tell them, hey, this is what's been happening.
Would I have a duty to do that?
Again, I would say it goes back, we cannot make a uniform duty. It's going to go back. I'm not trying to avoid this question, but I think they are so intensely fact-specific, we would have to have a better developed fact scenario in order for me to fully answer that question. But I think they're fact-specific, and when we look at the facts here, I think this is a situation where any reasonably prudent person would reach out and say to the responding officers, this is what's happened, this is what's going on, the guy's giving us some concerns. I see I only have a few seconds left. If there are no further questions, I thank you for your time. I thank you for the opportunity today.
Any other questions?
You mentioned that there were 4 undisputed facts, but I think you only told us 3. What's the 4th one?
The 4th one, I think, was simply the DPD records that Santander and Almeida were responding to an off-duty situation. It was the least important of the 4. Number 3 was the one I really hope that, if nothing else, I leave the court with today. Thank you.
Thank you, Mr. Illich. There are 5 minutes, I think. 3 minutes.
3 minutes. I do want to answer your questions, but let's see if I get a couple points in. On the Terry frisk, this goes back to, I think, the question that Justice Huddle was pointing at. Is it a must-do, right? So what their position to be negligent, that means all shopkeepers must frisk people. And I don't think that's the law anywhere. And that's...
Well, what about if they are going to do it, they have to do a good job with it?
Well, but that gets back to the, if they do it, what obligation do they have to do it, right? To be...
Well, they've undertaken to do it. So if you've done that, you should probably do it well, huh?
But again, the Home Depot policy would be you don't touch anyone, and that's why Officer Seward was saying I did it because I was concerned for safety as a peace officer because I've responded to this crime in progress. That he did at least investigate by figuring out that asking him how he was going to pay and whether he had any ability to pay. He found out that he had none because he had no money and no credit card. So to say that he is just acting at Painter's direction, at least on that regard, is not even accurate because he did ask some questions of his own right and come to conclusions about things on that level. But even beyond that, at the very first call, he's told, I want you to come over and criminal trespass. And that's what triggers the DPD criminal trespass policy as he's walking over there. Well, I'm going to have to get his ID. I'm going to have to do this. I'm going to have to do that, all of which is going to result in the warrant check and detention. But more importantly, on the issue of he didn't see the crime, I think Justice Young's question is accurate on this. It doesn't have to be seen. It can be in his presence and he has the authority to arrest someone. But more importantly, under U.S. Supreme Court precedent since the 70s, he can get information from a reliable source, which he testified that Painter was, that starts an investigation and starts a detention to go along the process of figuring out what to do with the crime. So it's not just as narrowly focused as I've got to see that, because that's not what the statute says. It says view in his view or his presence, and if he had to see it, they would obviously not have his presence.
If the private security officers are in an on-duty status, but are nevertheless following the instructions of the shopkeeper about do this or do that, don't scare the customers, you can imagine the shopkeeper trying to control the officers, and they're following his instructions. Does that put the shop back on the hook potentially if the instructions are faulty?
Well, no, because there are instructions that are meaningless and inconsequential. Don't scare the customers, let's go do this in the back, right? Inconsequential to how it goes down. Just like the customer or the complainant could say, I don't want to prosecute this charge, but I do want to do something else like getting him out of here. You've still done something under the Code of Criminal Procedure by showing up to interrupt the crime, right? And so you've prevented and stopped that crime from occurring by showing up there. But even if you concede to the fact that they don't want him prosecuted for theft, that doesn't mean that you still didn't show up as a peace officer in an on-duty capacity. And more importantly, getting into doing what they want at the criminal trespass warning, you're back into the bailiwick of the DPD policy. And I think those are all the reasons why he's on duty.
It sounds like maybe there are more policies that were or weren't followed to be aware of. Your friend on the other side mentioned that there were some others that should have been followed earlier if he was on duty, and so maybe both of you could send us a short letter about that.
Yeah, that one thing on policy I was going to say is there's not one that they pointed to that we didn't follow from the DPD.
Any other questions? Thank you, counsel. The case is submitted. That concludes the arguments, and the case is set for today. And in the cases, I will hear from the court. The marshal will adjourn the court.
Well, before we get to that, I imagine you've seen that there's some familiar faces here today. And thank you all for being here for this historic day and definitely the end of an era. Not an error. We did some calculation, and this was the 2,779th argument that Justice Heck has heard during his tenure on this court. Unfortunately for the state of Texas, it's the last. And I know that so many of you in this room know exactly what that's going to mean for the state of Texas. And certainly the 8 of us know what it's going to mean to all of us. So we have festivities planned, all kinds of exciting things, and we just really appreciate your being here to commemorate this great man who's done so many great things for so many people for so long. Thank you, Chief Justice Harris.
Now the marshal will.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.
Down.